Assalamualaikum to Madam Hafiza. My name is Emily DANISA binti Muhammad FADLI and I'll be presenting the importance of prudent indemnity insurance. So, this insurance offers the financial and legal protection to valuation firms, the employees, and also the clients. It covers the legal fees, compensation, and other costs arising from claims of professional negligence. Without prudent indemnity insurance, a firm could face severe financial consequences or even closure if sued for errors. Next, PII protects a firm's reputation and helps maintain clients' confidence. It demonstrates the firm's commitment to ethical standards and professionalism, which strengthens relationship with clients and supports long-term business growth. Next, in Malaysia, maintaining valid insurance is a regulatory requirement for registered valuation firms. A firm must renew their prudent insurance annually to maintain their registration with the Malaysian Board of Valuers, Appraiser, Estate Agents, and Property Managers or BOVIA. A failure to do so can result in suspension or revocation of the firm's registration. Next, prudent insurance covers financial losses caused by inaccurate or negligent valuations, including losses from incorrect property valuation during sales or purchases. It also covers legal fees and related expenses from negligence claim, ensuring financial protection for firms. Then, this insurance protects firms from losses due to the misrepresentation or failure to disclose relevant information. If a firm provides misleading details or fail to disclose key information resulting in financial losses, this insurance coverage applies. It also covers fraudulent acts by the employees. Next, this insurance covers losses from the misplacement or destruction of important documents such as property records or valuation reports. If clients suffer financial losses due to the such negligence, they can claim compensation under this insurance. As the conclusion, PII is crucial for valuation firms in Malaysia as it provides financial protection against error, negligence, and misconduct. It ensures compliance with regulatory requirements and helps maintain the firm's professional reputation, supporting its ongoing success and client trust. Thank you.
Assalamualaikum to Dr. Hafiza. My name is Nisrina binti Naim. Today I will present the use and purpose of the client account in relation to Rule 57 under Act 242. Under Act 242, every registered firm is required to maintain a client account, which is a separate and trust bank account used to strictly to receive and hold client monies. Client fund must not be mixed with the firm-owned fund. Firstly, the client account is used to receive and hold client money. All funds belong to clients must be deposited into this account and cannot be mixed with the firm-owned fund. Secondly, the client account is used to make authorized payment. Withdrawal are only allowed for purpose permitted under the Act, such as payment to or on behalf of the client, reimbursement of expenses, or payment of commission after a complete transaction. Thirdly, the client account is used for safeguard client fund. The registered firm holds the money in trust and it's prohibited from using it for unauthorized purpose, such as paying the firm operating expenses. Next, for the purpose of client account. Firstly, the purpose of client account is to ensure accountability and transparency. Proper record of all client money transactions must be kept to allow monitoring and auditing. Secondly, the client account aim to protect client interests and fund by ensuring that client money are used strictly for their intent purpose only. Thirdly, the client account serves to build client confidence and trust in the registered firm and the real estate industry, as clients ensure that their money is managed professionally and ethically. In conclusion, the client account play a vital role in ensuring honest, transparent, and professional financial practice among registered firms. It protects client monies, ensure proper use of funds, and strengthen trust in the real estate industry.
Assalamualaikum warahmatullahi wabarakatuh. My name is ZULKEFLI. Today I will like to present on the topic of misconducted techniques of registered value and appraisal with reference of Part 9 of the Value Appraiser, Estate Agent and Property Manager under Act 1981, also known as 242. First of all, it is important for us to understand why ethics are very important in the valuation profession. Valuers and appraisers play a major role in society. Our valuation report are used by banks for the loan, by courts for the legal case, by the developer for investment decision, and by the public determine property value. Therefore, if the value acts ethically, it can cause a serious financial loss and damage public trust. Because of this, Act 242, especially under Part 9, set out the clear rules on the professional conductor techniques and discipline to make sure valuer work with honestly, competence, and independent and responsibility. I will explain 5 types of misconducted and ethical issue together with a simple example. First of all, duty of service and competence. The first type of misconduct related to duty of service and professional competence under Rule 62 and 63. According to this rule, a registered valuer must always act in the best interest of the client or employer. The valuer must carry out the work with integrity, honestly, courtesy, and significant professional knowledge. A valuer must also know to accept work if he or she does not have the required experience or expertise. Misconduct happens when the valuer is careless or accept work beyond their ability. For example, imagine a valuer asks to carry out the very complex plan and machinery valuation for the court purpose, but the valuer has no experience in the area. If valuer proceed to without the seeking help for a qualified expert and produce an inaccurate report, it may harm the client legal case. This situation shows a lack of competence and demolish a professional standard. Therefore, it is considered a professional misconduct under Rules 62 and 63. 2. Breach of confidentiality and fiduciary duty. The second type of misconduct involves breach of confidentiality under Rule 63. A registered valuer must always act in fiduciary manners. This means all valuation reports and findings must keep in confidential. The information can be disclosed with the client permission or when required by the law, such as in the court. Misconduct occurs when the valuer reveals confidential information to the third party without approval. For example, if a valuer is hired by the developer to value a piece of the land for the purchase and the value share valuation figure or strategy which another competent developer is in a serious breach of trust. This action violates Rule 63 and may lead to disciplinary action under Act 242 because it damages the client interest and public confidential profession. Third, conflict in interest and failure to disclose. The third types of the misconduct is conflict of interest covered under Rule 62, 64, and 65. A conflict of interest occurs when the valuer personal interest interferes with a professional judgment. The law requires valuer to disclose any personal or business interest related to assignment. For example, under Rule 64, state a valuer would act as a estate agent for property must not later value the same property for the buyers. Rule 65 also requires a full disclosure of any relation or financial interest. Misconduct happens when the valuer hides such interest. For instance, if the valuer value a property for a bank but is secretly planning to buy the same property at a low price, it is a serious conflict of interest. The valuer's dependence and objectively are compromised. This behavior breach ethical duties and may be considered disgraceful conduct under Act 242. 4. Improper fees, commission, and profit sharing. The 4 types of misconduct related to fees and commission under Rules 16.6, 16.7, 16.8, and 17. Valuers are not allowed to charge a fee that dependent on the outcome of the valuation, such as charging a higher fees if the value is higher. This is known as a contingent fees and is affect the professional independence. Valuers are also prohibited from paying commission to unregistered person for introducing client. For example, if the valuer agree to develop which a developer to receive a percentage of the bank loan approved based on the higher valuation figures, this clearly influences that the value judgment. Another example, if the payer referral fees to unregistered property agent to get valuation job, both situations are considered professional misconduct and violate rules in the Part 9 of 8 under Act 242. 5. False, misleading and inaccurate report. This is the final misconduct involved with false, misleading valuation report under Rules 67 and 65. Valuer must ensure that the valuation report are accurate, truthful and complete. All important facts must be included and no material information should be hidden or surprises. Misconduct occurs when the valuer intentionally inflates the value, omits defect or hide legal issue. For example, if a valuer prepares a valuation report for the bank financing but deliberately fails to mention a registered caveat or the title restriction, to the report becomes misleading. This may cause the bank to approve financial based on incorrect information, such as British Rule 67, and may also lead to legal consequence under Act 242. In my conclusion, under Part 9 of the Act 242 plays a very important role regulating on the conduct and ethics of the registered valuer and appraiser. These 5 types of misconduct include lack of competence, breach of confidentiality, conflict of interest, improper fees, misleading valuation reports. This rule exists to protect client and the public and the reputation of the valuation profession. Any valuation may result in disciplinary action by the board and can seriously damage valuation career. That's all for me. I will pass to the next presenter. Thank you.
Assalamualaikum, my name is NURJANNAH binti ISMIL with matric card number is 20232168886. Today I will present a Rule 111 which is the matter forbidden in advertisement. The primary legislation that regulates the professional practice of valuation, appraisal, estate agency and property management in Malaysia is Act 1981 or Act 242. This professional play an important role in the property and the real estate development industry. Therefore, they are required to comply with the high standard of integrity, competency, and ethical behavior in the performance of their duties. To protect the public interest and to maintain professionalism, the government has introduced Act 242 together with the Valuer, Appraiser, Estate Agent and Property Manager Rules 1981. Although registered professionalism are allowed to advertise their services, Rules 111 clear outlines matters that are forbidden in advertisement, particularly to prevent misleading, unethical or unprofessional conduct. Under Rule 111, there are several matters forbidden in advertisement. First matter is inaccurate or misleading statement or fact. Under Rule 111, subsection A, any advertisement made by a registered valuer or valuation firm must not contain false, inaccurate, or misleading statement. This rule exists to ensure that information presented to the public is truthful, factual, and based on professional standard. Valuation is a professional process that relies on market evidence, professional judgment, and reliable data, not on guarantees. This is because valuation outcome depend on market condition, economic factor, and comparable evidence which cannot be controlled by any individual valuer. Therefore, such statements are not only misleading but also unethical and they constitute a breach of Rule 111 subsection A under Act 242. Next, Rule 111 subsection B prohibit valuation firm and registered valuer from explicitly soliciting instruction through advertisement.
This means that advertisement must not directly urge, persuade, or pressure the public to hire their services. An explicit solicitation refers to a direct request for client to engage the firm without considering individual needs or circumstances. This rule is important to preserve the dignity and professionalism of the valuation profession. Valuers are expected to obtain work based on expertise, reputation, and merit. For example, an advertisement stating that clients should immediately call and appoint the firm for valuation matter would be considered explicit solicitation and is therefore prohibited. Under Rule 111, subsection C, advertisement must not explicitly or implicitly compare the services of one valuation firm with those of another firm. The purpose of this regulation is to prevent unfair competition, professional conflict, and negative public perception. Comparative advertising may misrepresent the capabilities of other firms and undermine the integrity of the profession. For instance, if a valuation firm claims that its valuation reports are more accurate than those prepared by other firms, this would be considered an explicit comparison. Such claims suggest superiority and may unfairly discredit or professionals. Act 242 emphasizes that valuers should promote their services without degrading or disparaging others in order to maintain mutual respect and ethical standard with the profession. Lastly, Rule 111 subsection E prohibits the use of self-laudatory statement in advertisement. Self-laudatory statement refer to the exaggerated claim of superiority or excellence that cannot be objectively proven. This statement may mislead the public and compromise professional integrity. For example, claiming to be the number one of the most trusted valuation firm in the country is prohibited, as such claim lack verifiable evidence. Professional credibility in valuation should be established through competence, ethical conduct, and compliance with the Act 242 rather than through boastful marketing. In conclusion, although registered valuer and valuation firms are allowed to advertise their services, Act 242 and Rule 111 impose clear limitations to ensure ethical and professional conduct. That's all from me. Thank you.